Good morning. Have you got your labor law book, the Act? Did you bring the Labor Act? The first thing the judge should do is to take the particular rule or code. When counsel knows you don't have the book, they will tell you some section 18 says this. And if you have not read it, you can't argue with counsel. Okay. But you must have a copy. Because this is statutory labor law. It's not common law labor law. So it cannot be in the bosom of the judge. That's the first thing we learn. I'm dealing with the jurisdiction of the labor court. And the jurisdiction, I think it's better I stand here. Yeah. The bench is for the judge, podium is for politicians. So that I can look at the act at the same time. Okay. We are looking at the jurisdiction of the labor court. That is the most important. The entire act, if you are sitting on the bench, that's the most important. Because that you have to be able to determine whether you have power to hear any matter at all. You don't hear, if you are sitting, those who, magistrates, and you know, where a point is raised, preliminary point is raised, if it's on jurisdiction, you cannot hear the matter. You must hear the matter. Certain points in preliminary points, you can hear the matter and decide later on. It may not. But when it comes to jurisdiction, you must hear that matter first to determine whether you have jurisdiction at all. If you don't do that, you are being foolish. You sit for 4 days, 5 days, only to realize that you didn't even have power to hear anything. And a judge shouldn't be seen to be foolish. So jurisdiction that's why it's so important. Initially, you hear counsel making that point. They want to, whether it is. And why do I say? Because we have the High Court and the Labor Court. The Labor Court is a division of the High Court, but it is not the High Court. Not that because it is part of the division of the High Court, it can hear everything that the High Court can hear. It's only a division of it, and its powers are circumscribed in the Act. So jurisdiction becomes so important. You must determine whether you can hear a matter or not. Don't immediately a point in limine is raised on jurisdiction. You must hear that first. Any other preliminary point you can hear and later on determine whether it makes sense or not. By jurisdiction, you must hear it first. Okay. Let me read section 116. The Labor Court established by Section 15 of the Labor Act is continued as a division of the High Court. The reason is that the Labor Court, which existed in the 1992 Act, didn't know where it was. Was it a High Court? Was it a lower court? Was it a Supreme Court? It was hanging there. And it looked a bit unconstitutional. And that's why Judge Maris decided that it was a lower court. When a High Court judge is sitting in the repealed Labor Act, he was sitting in a labor court because in terms of the Constitution, a court must fit into Supreme Court, High Court, lower court. If you don't fit in any one of them, you're not a court. So he decided, let's put it in the lower court because it's not a High Court. That's why the lawmaker decided to make it division of the High Court. And then the Labor Court has exclusive jurisdiction. Exclusive means exclusive. It means the High Court cannot hear a matter which is within the power of the Labor Court. There are appeals, so I'm going to deal with appeals, review, and then the rest. First, we are going to deal with appeals. The Act says if the Labor Court can determine appeals from decisions of the Labor Commissioner made in terms of this Act. The most important thing to take into account in this Act, you must read every single word properly. And they are all connected. You will see as I go through, you see that all the sections are connected. You see, it says appeals labor in terms of this Act. So whatever decision, and then it goes on. If it's not in terms of this Act, you cannot. The Labor Commissioner has other powers in other statutes. But you appeal only a decision he takes in terms of this Act. And then that is 2, arbitration tribunals awards in terms of Section 89. You can see, it doesn't say arbitration awards, full stop. Arbitration awards in terms of Section 89. Then you have to go to 89. You can't understand this Act unless you are prepared to read backwards and forwards. If you go to 89, a party to a dispute may appeal to the Labor Court against an arbitrator's award in terms of Section 86. You see, it takes you back to 86. That's why I said you have to be very careful while you're interpreting the Labor Act. On any question of law only. It doesn't say you can do appeal on anything, only on a question of law only. B, in case of an award in a dispute initially referred to Labor Commissioner in terms of Section 71A, on a question of fact, law, or mixed fact and law. Section 71 is more about human rights. So you can see, already we have seen Section 89, Section 86, Section 07. You cannot understand it unless you read through it. And many counsels make that mistake. They make beautiful arguments, they see that they have missed a section. Because it's a statutory power, not common law power, the power of the Labor Court is circumscribed. I was given only 1 hour. It's impossible to do any labor thing in 1 hour. Impossible. Unless I'm going to read the notes to you. I'm coming to do costs. We'll take another time on cost. Actually, it's cost which needs less time. So, is there anything so far you wish to ask? It shouldn't be a lecture. You are not in the law school. Is there anything you wish to ask? Or I have missed? Okay. And then 3, if you go to, so those are the appeals. If you read the statute, you will understand what. So long as you can go back to the section they are referring to. Okay.
Can I ask a question?
Yes, please.
Are you saying that in terms of the Labor Act, a party cannot run to the High Court before dealing with other remedial actions like arbitration and so forth?
Actually, we are coming to that.
Okay.
You are reading my mind. We'll come to that. But your short answer is that, yes, you cannot just rush. You cannot, when you come to the High Court, you can rush to do so many things. On agency, we are going, one of the powers is agent relief. And you see that it's very different from the High Court. And many, many senior counsel have been thrown out because of that. They thought you can rush to the High Court because it's a division of the High Court. But the Act doesn't say that. It has got its own powers. Okay. Anything so far? We are looking at appeals, then we'll go to review. It's appeals, review, and other things. When it comes to appeal, not everything that you can come to the Labor Court. It should be an appeal against arbitration award made by the arbitrator to whom Labor Commissioner has referred the dispute. If Labor Commissioner did not refer the dispute, there's no appeal. Why have they made that distinction? There should be an appeal against an arbitration award made by an arbitrator who was appointed by the Labor Commissioner. Why? Because Labor Court is not the only arbitration. Arbitration is not only in the Labor Act, because there are private arbitration in Namibia. An employer and an employer can decide to go to private arbitration. So, of course, it's expensive for the employee. So it must be an award made. You can say it's just the award, the arbitrator's award, not anything that he does. Let me give an example. Somebody comes to court and says, when I went to arbitration, I wanted postponement. The Labor Commissioner, the arbitrator refused. So I'm coming to the High Court. Is it an award? Has he made an award? No. He hasn't even started hearing the matter. And that's why it's important. So it should be an award. If an award has not been made, there's no appeal in terms of Section 89. And then we say questions of law and fact only. What's the question of law? What's the question of law? You hear it everywhere. In every common law country, you hear a question of law, question of fact. What's the question of law? A question of law is simply a question on, let me read what. A question of law is a question determined by authoritative legal principles. That is the correct answer. It's a question which can be determined with reference to authoritative legal principles. Why do I use the word authoritative? What's the meaning of authoritative? Why don't I say it's just a question determined by legal principles? That is, legal principles which have been determined by the court. Those are legal principles, authoritatively determined. Not by text writers, by courts. So what is that? The court seeks to ascertain a particular rule of law. And the court can do so by, of course, you can refer to textbooks, but you go to authoritative legal principles. The reason is that what a textbook writes, compared with what a high court judge decides, if it has not been set aside by the Supreme Court, is the law on that principle. Not what Baxter has written, Christie has written, Netherland has written, or even Parker has written, but what a high court or Supreme Court has decided. That's authoritative legal principles. When it comes to appeals, when you read, and they said it's a question of law only, where, that's why it goes a bit with facts, where the court takes a decision which is perverse because there was no evidence on the facts before him, where you take a decision on the wrong facts. That's perverse finding of facts is a question of law when it comes to appeals. So when they say you have a power to appeal, question of law only. Apart from authoritative legal principles, it's also a question of law where the decision maker, the arbitration or the judge or the magistrate has perversely found a fact which did not exist. So his decision is based on a perverse fact. That's also legal question of law. The arbitrator takes a decision where there was no facts before him. That's a question of law when it comes to appeals. Any questions so far? So what we said was the general principle, but when it comes to appeals, when an act says you can only appeal on a question of law only, perverse finding of fact is a question of law. Where the magistrate or the judge, arbitrator took a decision, the tribunal a decision, where there were no facts before him. And on the notes, you see there are two cases, Romingo versus Van Wyk, and then Jans van Rensburg. One is a Supreme Court decision, which actually refers to Romingo. That's why the two cases are important. You don't have the act. Okay, let's go to 89(1)(b). We have finished the question of law. Okay. And it should be a decision against an object award made in terms of Section 86. Section 86, do you know the Act very well, or sufficiently well? The Labor Act? Okay. Let me read 86. 86 is resolving disputes by arbitration through Labor Commissioner. Let me tell you one thing which many people don't know. Many people make mistakes even in court. When an employee is dismissed, there must be a disciplinary hearing, internal. There must be an appeal by all means. There must be an appeal process internally. If there's no appeal process, the decision is wrong from the beginning. There must be an appeal process. So you start from disciplinary hearing, appeal internally, and then you're not happy, or the employer is not happy, you report a dispute to the Labor Commissioner. He does not appoint a conciliator. He appoints an arbitrator. Where he appoints an arbitrator, a conciliator, from the beginning, is only a question where the dispute is a dispute of interest. You know dispute of interest and dispute of right in labor? Oh, then I'm speaking ahead of you. Okay. In labor law, there are two disputes, two main disputes. Dispute of fact, dispute of right, and dispute of interest. 86 on dispute of interest. If you go to chapter 8, if you go home, read chapter 8 of the Act, and then you understand what I'm talking about. Chapter 8 deals with there's disputes affecting the national interest. We call a Part A dispute. There's a Part B dispute, conciliation disputes. And the Act defines what is a dispute in each case. For instance, Part B dispute, a dispute of interest. I'll explain what that means. A dispute referred to Labor Commissioner in terms of Section 45 of the Affirmative Action Act. Dispute referred to then C by the Minister or by the High Court. Dispute of right is where the dispute is on a contractual matter. It's a right. Let me give an example. If you think you are very clever, but you have all the degrees, but you are put at this post. That's what your contract says. Your post is post B, salary is 1,000. If you're not happy with it, you have no recourse in our law, because you don't have a right to it. And one person does not go on strike in Namibia. Dispute of interest is where, that's why it's called dispute of interest, is where a group of employees are looking for something over and above their contractual assets. They are looking for, that's why some people, when workers are going on strike, they are looking for something better than what their contract says. So if it's not a right, and you can only, as an employee, you have a right in terms of your contract of employment. You know, so the manager and director told me, oh, I can have a car as part of my conditions. It's not a right. the solution of a dispute of right, that's what the High Court deals with, an arbitration. Dispute of interest, the workers don't go to court, they take industrial action. The employer can take industrial action. What industrial action can an employer take? What industrial action does an employer take? Lockout. You have heard lockout before? That's industrial action, but only by an employer, where the employer closes his doors and doesn't allow anybody in, any worker in. Industrial action is taken by an employee by going on strike and picketing. When they do that, they are not insisting on a right. They are saying on an interest. They saw the managing director buy a new car, he changes today, it was ML3, it's now ML5. The wife comes in a very nice shoes. He said, no, there's business, there's money in this workplace. But he tells her there's no money. So they want more money. Not that it's in their contract. Okay, any questions so far? A question of fact is a question which is capable of proof. That's simply that. Question of fact is a question capable of proof, and that's why evidence is led for that purpose. That's a question of fact. It's a question which is capable of proof, and evidence is adduced for that purpose. When it's a dispute of interest, you don't see people, don't use the word come to court. People don't come to court. What they do is to take industrial action. The employee can go on strike and picket. The employer can lock out. These are the two they have. They come to court where, let's say there's a lockout by the employer. They come to court to ask the employer to open his doors. Okay? Dispute of interest, they go on strike. The employer comes to court to tell the court that they have not complied with the act. Because the act sets out how you can go on strike. You don't just wake up one morning and say, I'm going on strike. Huh? You don't ring your friends, or you were drinking yesterday, so we are going on strike tomorrow. And you go on strike. Why? Because my wife is asking for so many things, I don't have money. Oh, my wife also. And my father phoned me, say he needs a lot of things. And then I think the money we get is too small. We go on strike tomorrow. You don't, so you go through a process. Okay. So when they come to court, they don't come to ask you that they want to go to court, they don't want to go to court. One comes to court if there has been an unlawful lockout, or they allege, and the employer comes to court if he perceives that there's going to be an unlawful strike. Unlawful strike is a strike which is carried out without compliance with the act and the rules. The most important, you decide to go to appeal. As I told you, when it's a dispute of fact, and report, if you are dismissed by your employer, and you go to disciplinary hearing, you are found guilty, you go to appeal, they uphold the dismissal, there's an unfair dismissal you allege. You report a matter to the Labor Commissioner. What he does, he doesn't set up a conciliation. He appoints an arbitrator. I can tell I've read some judgments which misses those things. They don't appoint a conciliator unless it's a dispute of interest. Then the arbitrator, his job is to arbitrate, but the act says he must conciliate first. So he's an arbitrator conciliating. When conciliation fails, then he must arbitrate. But he's an arbitrator. So he takes a decision, he makes an award which you're not happy about, then you appeal. So, but you can appeal only a question of law. that he misinterpreted a principle of law wrongly, and you cite all your authorities, or he made perverse findings of fact, then you appeal to the High Court, to the Labor Court. As a judge, the most important thing, it's not whether someone is appealed, that is right, is the noting of an appeal. Noting of an appeal. Let's go to 86. Unless the collective agreement provides for a referral of dispute to private arbitration, a collective agreement can decide that for us we go to private arbitration. So unless it's that, or the labor office, there's time limits. Time limits are so important in labor act, in labor law. And you don't condone time limits if you don't have power to do that. You don't. If you have power to do that, the act will tell you have power. If you don't have power, don't let any smart counsel persuade you. You must have power. It's not a discretion. It's not inherent power, because this is the Labor Act. Okay, the Labor Commissioner must refer the dispute to an arbitrator to attempt to resolve the dispute through arbitration, and then determine the place and so on. So, unless the dispute has already been conciliated, the arbitrator must attempt to resolve the dispute through conciliation before beginning arbitration. That's what I'm saying, yes.
So is that only respect of disputes of interest?
Of right. What we call part, say, if you look at that, chapter 8 is the most important. The dispute affecting national interest. Dispute means any of the following disputes: of interest, affirmative action, the ministry, and then it goes on. Yeah, if you go to part B, they are called conciliation disputes. These are disputes, it has been defined. Dispute of interest, dispute referred to Labor Commissioner in terms of Section 45 of the Affirmative Action Act. So it has been defined. And if you go to subsection 15, subject to Section 83, a conciliator must issue a certificate that a dispute is unresolved. And then that's when it can go to arbitration. But for dispute of right, it goes to a Labor Commissioner. He appoints an arbitrator. The arbitrator is an arbitrator. He must conciliate first before he arbitrates. Anything more? It's already 12.
What does the conciliation process involve, Judge, before the arbitration?
What does conciliation?
Yes, what does it involve?
Okay, if arbitrator is conciliating, he invites the disputants, the employer, the employee, and then he tries to conciliate. Means he tells them you have this problem. He doesn't propose solutions. He doesn't propose. They must propose solutions. Then he advises them. If you do this, no, you cannot ask for this because it's not in your contract of employment. You cannot ask this because it cannot be. So that's the meaning of bringing you together, conciliating your differences. Mediation is different. Mediation, the mediator can propose. That's different between conciliation and arbitration. Can propose a solution. Sells it to you, the disputants. Conciliation, he tries to conciliate your differences. You should tell him what you want, and then he will tell you, you cannot do this because the act does not, or the collective agreement does not allow it. So that's conciliation. It's usually done by he tries to just solve the problem amicably, but he doesn't propose solutions. Let me ask you a question. If an arbitrator, before he starts, one of the parties says, oh, my lawyer is not here, the issue the employees. Can you stop for some time, postpone the matter? He says, no, but he knows that is today. It's 10 o'clock, and it's 10:05. I'm going ahead. That's the arbitrator. Then he goes ahead. One important thing you must remember, an arbitration, that's why it's called arbitration tribunal. Arbitrator is a tribunal. Not when even if he's a permanent secretary, he's not sitting as an administrative official. Get that is very important. I'll show you why it's important. It's a tribunal in terms of Article 12(1) of the Constitution. And Section 85 says so. They are established as completed in Article 12(1)(a) of the Namibian Constitution arbitration tribunals. So they are tribunals. So they must behave a bit like a court. Hear evidence, weigh evidence, apply the law, and take a decision. If you tell your permanent secretary, I want to go on leave, he doesn't apply any law, he doesn't hear any evidence on oath or affirmation, he doesn't. So it's a tribunal, so it must behave like a tribunal. Into Article 12(1). Section 85 says so. I was asking a question. The arbitrator, then somebody says, no, my lawyer is not here, he's a bit delayed. The arbitrator says, I know your lawyer, he is always late. I am not going to wait. One time I waited for 10 minutes and he was not here. One time, 1 hour, I'm going ahead. He knows it's today. Then he goes ahead. And he takes the decision. Can you appeal against that decision for failure to postpone? You are in court and such a matter comes. You look at it, the papers, he's appealing against the refusal of the arbitrator to grant him postponement. More hands. Did you understand the scenario? Goes to arbitration, the employee. Then when the time to start, so my lawyer is not here. This is your lawyer, I know him. He is always late. Sometimes 1 hour. I don't have time. I have another arbitration after this. Then he goes ahead. So you are aggrieved. The employee is aggrieved. Then he brings an appeal. He notes an appeal in the labor court. Can the labor court hear such a matter on appeal?
I would say no. I remember you said that an appeal can only be noted after an award has been made.
Yeah, you appeal against arbitrator's award. That's what 86, where the power is 89. A party to a dispute may appeal to a labor commission against an arbitrator's award made in terms of Section 86. So you report to labor commissioner, he appoints an arbitrator. So he's in terms of Section 86. So it should be an award. Okay, one, in terms of our law, let's start from the beginning. Legal representation is not a right in disciplinary hearing unless the complexity of the matter demands that there must be legal representation. I've done a case where the person wanted legal representation and at disciplinary hearing, and he was refused naturally because they are not lawyers. They have no legal training. And they brought a review. I reviewed that decision because the matter was so complex that it needed a legal practitioner. So but you don't have, it's not as of a right like in court. Okay. In arbitration, it's a tribunal. Let's go to section. That's why I said this act you must read. It's not something you can answer that can there be legal representation. The act says an arbitrator may permit a legal practitioner to represent a party to a dispute in arbitration produced if, one, the parties to the dispute agree. And you are sure the employee will not agree if he hasn't got a lawyer. And then 2, at the request of a party to a dispute, the arbitrator is satisfied that the dispute is of such complexity that it is appropriate for a party to be represented by a legal practitioner. And the other party to the dispute will not be prejudiced. So it's not just even where the arbitrator thinks that the matter is complex, and therefore he must allow legal representation. He must still satisfy himself or herself that the other party will not be prejudiced. So it's not a matter, it's not an entitlement. You're talking about internal disciplinary hearing, not arbitration. No, which one?
But as it follows,
No, which one? You're talking about internal, we call internal disciplinary hearing or internal appeal hearing, and then arbitration. Which one are you talking about? No, but you cannot say the whole process. There are 2 different processes, internal disciplinary hearing and then internal appeal hearing. As I said, there must be an appeal internal by all means. If not, the whole process is procedurally unfair. There must be internal hearing and a right of someone to appeal. And that right should be read to him during the internal hearing. That this is my decision. If you're not happy, like you do in the magistrate court, you can appeal to the internal body. You must tell, it must be on record. If it's not on record, it's procedurally unfair. Okay, So what's your question? So that's internal. Then after the initial hearing, appeal, he's not happy or employer is not happy, they then report a dispute to labor commissioner who appoints an arbitrator. Okay, so which level are you talking about? At the arbitration.
yes.
Arbitration, as I've told you, you cannot, it's not of right to have legal representation unless the 2 parties agree. The employee says, oh, we have all got lawyers. The employee says, I don't have a lawyer, I don't have money, we don't want one. Then the arbitration must decide. And he decides, he hasn't got untrammeled discretion. His discretion is guided. He must decide whether the matter is complex. And if he says complex, he must still decide will the other party be prejudiced. Let's say the employer brings 5 senior counsel. Arbitrator will not allow. They say the person will be prejudiced. He doesn't even know how to read or write. So he decides that in my you can't have representation. But for the internal, our common law is that one has not got a right of legal representation at internal disciplinary hearing or appeal. Okay, yeah. And shall be entitled to be defended by legal practitioner of their choice. All persons shall be afforded adequate time and for the preparation of and presentation of their defense before the commencement of and during their trial, and shall be entitled to be defended by a legal practitioner of their choice. Would you say that arbitration is a trial?
No, but okay, even if it's not classified as a
No, not that even if. You read a statute globally.
Okay, let's say it's a hearing. I would say it's a hearing.
No. Just take your time. You say a trial. You cannot replace trial with hearing. You think if the constitution maker wanted to hear, they wouldn't have put the word there? Is that what you think? That if they wanted, they wouldn't have put hearing? You think they didn't know the word hearing?
That's a matter of semantics.
No. Never, in law, never assume things which are not there. If it's a statute, it's a statute. You think they didn't know the word hearing? The constitution makers? There were attorney generals there. They knew. They used the word trial. So don't say it's the same. It's not the same. Trial is not a hearing. Even in the High Court, we don't refer to applications as a trial. Even in the High Court. I don't say there's a trial going on if I'm hearing an application. I say there's a hearing. So the two are, even in law, is different.
Okay.
And if the Constitution says a trial, how can you say arbitrary term is a trial? Trial of who? A trial, you try someone. Am I wrong? So whom are you trying?
Okay, let's agree to disagree.
No. I want to persuade you. Since you want to be a judge.
Let me
Since you want to be a judge, I want to persuade you.
Can I just give you
Listen very carefully. When you're reading a statute, don't change words, add things. I've written a judgment where somebody was adding things to the Constitution, Article 12, Chapter 3. I said that when the makers, they put that, you have a right to do this, right to do this, right to... You can't add things to it. You cannot. It's platitudinal. You cannot. When you're reading a statute on human rights, go to what has been said. If you're reading any instrument on human rights, don't try to be creative. E says, you see, E starts a capital letter. It has no chapeau. You understand chapeau? Chapeau are words which introduce words, sections in an act. It has no chapeau. It's on its own, independent. No, let me give an example of a chapeau. If you look at 2, searches of a person or the homes of individuals shall all be justified where these are. The first one is a chapeau. This one is on its own. The E is on its own. Standing on its own. You read with a capital letter. All persons shall be afforded time and all that, and shall be entitled to be defined by legal power of their choice. Talking about a trial. So I don't see, it has not been brought to the higher court. It has not been argued. Supreme Court has not decided. So let's say that let's wait until Supreme Court decides.
Okay.
Or the high court decides.
So we're saying that an arbitration is not a trial.
It's not a trial.
Or it's a hearing.
Yeah.
So if it's a hearing...
Try is an English word. There's nothing like legal word. Remember that. Never forget that. There's nothing like legal word. If it's Afrikaans, it's Afrikaans. If it's English, English. Try is an English word. There's nothing anywhere in the world, legal word. No. It's a language. Try means a trial. Trial cannot mean anything apart from a trial. Even in the High Court, when there's an application, we don't say there's a trial. Why? Because nobody has been tried. If I'm going to hear an application, if you ask me, I don't say I'm going to trial an application. I say I'm going to hear an application. It's an English word. And never forget, if you've not told in the university, there's nothing like legal word. It's a language word. If it's Oshiwambo, it's Oshiwambo. If it's English, it's English. If it's Latin, it's Latin. If it's Afrikaans, it's Afrikaans. There's nothing like legal word. Having its own meaning than the dictionary meaning. Never forget that. If you forget that, you make a big mistake. You'll be trying to change words to suit what you think is correct. Try is an English word. Okay, that's my view, unless set aside by the Supreme Court. Okay, let's move on. The most important is notion of an appeal. That is the most important, which you must be very careful about if you are sitting. I'm going to read through. As I said, I'm going to give you the notes. In terms of the Act, I'm going to the process. In terms of section 82, 89, 2, and 3, an appeal must be noted within the time limit of 30 days. After the person who wishes to appeal was served with the arbitration tribunal's award. And the appeal must be noted in terms of the rules of the High Court. That's the most important. It says it must, at the time that 30 days after the arbitration hours, the person was served. If the person has not been served, it is wrong to say, people argue in court, He was there. He heard everything. That is not service. I've heard counsel argue like that. Oh, the employee was there throughout with his lawyer. He has not been served. He must be served. And service is in the rules, how service should be carried out. These are things you must be aware of. You'll be cheated in court. If you don't, it says served. You cannot say, no, but he was there with his lawyer throughout. He heard that word. He was there, so why should we serve him? Served. So if he says 30 minutes have passed, I have not been served. So why are you bringing an appeal like this? I have not been served. You cannot say you are late, because sometimes you say 30 days has passed, because the arbitration was, it's not the date of the arbitration, it's the day that the person was served. So you cannot say, no, it's 1st of June, and I brought it within 30 days. It must be when he was served. Labor Code has got own rules. There's services on Rule 5. Service of any process may be effected in one of other of the following manners. So it has got its own service, mode of service. Let me read one which is always a problem in the court. Service of any process may be effected in one or other of the following manners, namely, by handing, there's a spelling, if you read it, there's a spelling handling, but it's handing. By handing a copy of the process to the person concerned. The person concerned be the party. So if you are the employee, the employer. Employer, employee. 2, that's where the problem is. It may look very harmless. People have lost cases because of just that simple thing. A representative authorized by the other person to accept service on behalf of that person. I've done a case where I threw the appeal out, the service out, because it was served on the labor representative who represented the person both at the disciplinary hearing, appeal, and arbitration. Counsel's argument was that, oh, this person had been with him throughout. I said, and so what? Who told you he has not parted ways? He was the legal practitioner. So no, but the legal practitioner was there at the arbitration. The person concerned. How do you know? The legal practitioner's brief has not ended. How do you know? And that does not say so. It doesn't say if he was present legal practitioner, you could serve it on. It said the person concerned. Let me read it. Then you can decide whether it is accepted. By handing a copy. Handing a copy. Not by email. Not by email, by handing a copy. Copy means copy. Don't argue that email is also a copy. Copy is an English word. By handing a copy of the process to a representative authorized by the other person to accept service on behalf of that person. So you cannot say it's a power of attorney. They would have said so. If the legal practitioner involved, service on legal practitioner is service, like in the High Court rules. Okay. And they say 30 days. Let me read something to you. In terms of 89, the labor court has the power to condone late filing, late noting of an appeal. That is 89.2. A party to a dispute who wishes to appeal against arbitrator's award in terms of Section 1, in accordance with the rules of the High Court, within 30 days after the award being served on the party. 30 days. Then 4, a party to a dispute, the labor court may condone the late filing, the late noting of an appeal on good cause shown. So the labor court can. But it cannot unless there's an application to condone. not from the bar. Application is not moved from the bar. There must be a proper formal application with an affidavit explaining, served on the other party, and then argued. The next important one is in terms of the rules. That's where the biggest problem arises. Those of you who are familiar with the Act, there are rules made by the Deputy Judge President as Judge President of Deputy Chief Justice as Judge of the Court. He made the labor court rules. Then there are rules, Code of Good Practice Industrial Action. It's done by the minister. Then there are rules made by the minister. They call them labor general regulations. That is where the biggest problem is. Some lawyers don't even know this thing exists. That's why they do only labor court rules. It exists. I don't know why they did that. Let me ask you a question. Somebody notes an appeal. He notes an appeal. As I say, appeal, there are so many rules you must obey. If you don't obey, it's not an appeal. Can he come to labor court and because he noted the appeal late, 40 days late? But he has not noted the appeal in terms of the rules. Would you condone such an application? Can I repeat? Okay. Let me read this to you first before I repeat. The labor court may condone the late noting of an appeal on good cause shown. That's if the good cause is shown, it gives good reasons. But the exercise of labor court is restricted to appeals that have been noted in terms of the Act. And noting appeal is a long process. One, in terms of Rule 17.1 of the rules of the High Court, of the Labor Court. Then, in terms of this rule I'm talking about the minister's rules, there are two forms. There's a form LC1, LC41. You see all that in my notes. And then form 11. Form 11 comes from the Labor Court rules. Form LC1 comes from the minister's rules. If these two are not there, there's no appeal noted. And we are strict in the court about that. The two must be there. One is called LC 11, is in terms of the rules of the labor court. The other one is LC 41 in terms of the minister's rules. Let me give you the full name. It gives the minister the power to make rules, and then the minister makes rules. The forms are so important. You attach the forms. If the forms are not there, let's say you just note with LC 11, but no LC 41. There's no appeal properly noted. So whether he did it 20 years after or 5 days later, it doesn't matter. You cannot condone it. What are you condoning? There's no appeal before you. No, okay, it's in my notes. Let me read it. What the labor court can condone late noting of an appeal. It means that appeal is properly noted. The only mistake is that it was done after 30 days. If it hasn't got the notice, it must got LC 11 and then LC 41. If they are not there, it means there's no notice of appeal. So what are you condoning? It means there's no appeal before you. You are condoning an appeal which has been properly noted, but for the time, for the 30 days. They're in my notes and there are cases on it. Another important point, prosecution of an appeal. In terms of Rule 1716 of the Labor Court rules, a person who has not an appeal must prosecute the appeal within 90 days. If it's not done, in terms of Rule 1725, the appeal lapses ex lege. Just by operation of law, it lapses. Now somebody will ask, what's the meaning of prosecution of an appeal? Fortunately, those who are magistrates know it. It was a problem in the Criminal Procedure Act where you must prosecute an appeal within a matter of days. The question was, when does it, prosecution means what? Because an appellant has no control after he has put in papers. He cannot say, I want my appeal to be heard tomorrow, next year, next week. He has no control. So because of that, the labor people were very clever. They have decided that when, after noting the appeal, you must ask the registrar to set the matter down for hearing of the appeal. You see, I didn't say trial of an appeal, hearing of an appeal. When you give that notice to the registrar, you have prosecuted the appeal, because it's no longer in your hands. But if you don't request the registrar to set the matter down within 90 days, then the appeal is deemed to be lapsed. And no court can revive it. No court. No amount of reason that you have. Because it lapses as a matter, as operation of law. And it's a statute. It's not a common law. So an appeal which has lapsed in terms of Rule 1725 of the rules of cannot be revived. The court has no power to revive it. It dies by operation of law. 17.5 years. Or the rules of the High Court. So rules of the Labor Court. you know the appeal, and then you must request the registrar to set it down. Yes. By merely send a notice to the registrar to set the matter down, you have prosecuted it. And you must do all this within 90 days.
Whether the registrar does
Yeah, because you have no control over the registrar.
Okay, but then does the operation of law take its course?
No, it means you have prosecuted it.
Okay.
Yes. So it cannot lapse.
Okay.
As I said, it was those who are familiar with magistrate court, the Criminal Procedure Act, it created a lot of problems. When the prosecution made? Is it when the matter is heard? Appeal is heard by the court? But an appellant has no control over the court. And that's why they decided to put it in the statute. That if you note your appeal within 30 days, within 90 days you must prosecute it. And what that does mean, it means you must send a notice to the registrar asking her or him to set it down. Whether he does it, he doesn't, does tomorrow or does not, you are prosecuted because you can't control the registrar. It's 12:30. What do we do? As I said, I'm surprised anybody put labor jurisdiction within 1 hour. It's impossible. Because we have not even done review, and the two are. Until 1:45, I'm going back to court. So let's do it up to about 1:45. And as I said, when we don't finish, when I'm doing probably it's Lorraine who put the program. They ought to have put costs. More cost doesn't 1 hour you can. So if you don't finish, you can take 30 minutes out of the cost, because that will not take long, and that's 3 hours. Yeah. Okay. The other one is review. This is also very important. It's not reviewed by the High Court. High Court can review any decision by an executive body official, by a tribunal, by the lower court. This is review, and in terms of this act is one, and there are too many, there are about 3 sectors. Arbitration tribunal award made in terms of the act. That is the first one. any award made by the arbitrator. And it should be an award. So the example I gave earlier, where arbitrator refuses to postpone, you can't review that decision in terms of this act. It's an award, arbitration tribunal's award made in terms of the act. So there must be an award. And 2, decision of the minister, Minister of Labor, or Minister responsible for Labor, Permanent Secretary, Labor, Labor Commissioner, any other body or official. The most important, as I said, if you read the Act, there are so many qualifications. First qualification is that it must be in terms of the Act, the decision. In terms of any other act, so long as that decision relates to labor or employment for which the minister is responsible, not just any labor matter. In terms of the act, that's a decision by the minister, permanent secretary, labor commissioner, any other body official in terms of the act. It means the official body must be within the act, not any body. And then in terms of the act, so long as it was in terms of the act, in terms of any other act, that is any other act in Namibia, so long as that decision relates to a labor or employment for which the minister is responsible. If the minister is not responsible for it, even though it's a labor matter, but the minister is not responsible, you cannot review that decision. Who can think of any act? Why is she wrong? She made Public Service Act. It deals with employment and all that, but why is she wrong? The Minister of Labor is not the Public Service Act, it's the Prime Minister. These are things we must be careful about. It says, in terms of any other act, so long as, I've just put so long as, the act doesn't say so. So long as that decision relates to labor or employment for which the minister is responsible. If it was full stop to employment, of course, the Public Service Act, the Correctional Services Act, the Defense Act, they are all employment and labor, but the Minister of Labor is not responsible for it. Okay. Who can mention any act where the Minister of Labor is responsible for? Employees Compensation Act. It used to be called Workmen Compensations Act. It's called Employees Labor. The Minister of Labor is responsible for it. The 1996 Act. The next one is the most confusing. It is C. Those who have the Act is 1171C. If you're not good at statutory interpretation, you have serious problems with the Act. You must be very careful with statutory interpretation because there are so many qualifications and modifications. Review despite any other provision of any Act. Any decision of any body or official provided for in terms of any other Act if the decision concerns a matter within the scope of this Act. Can I read it slowly? That it can review, we have seen one review, where it can review the arbitration tribunal's award decisions of the minister, permanent secretary, labor commissioner, any other official within the ministry. C, so you can see there are 2 levels of review. Review despite any other provision of any Act. No matter what any provision Act says, it can review any decision of anybody or official. It doesn't mean labor commissioners and labor inspectors. Provided for in terms of any other Act, not the Labor Act. It has not finished. if the decision concerns a matter within the scope of this act. Does everybody understand it? That's the one who creates problems in the court for everybody.
But that is also then the act that she refers to.
But that is C.
Yeah, that's what I'm saying.
Yes, that is C, not E. We are talking about, we are in C now. Yes, yes. That's why you must read every phrase, everything correctly. That one when the minister is responsible. What about if the minister is not responsible? Like the Correctional Services Act, the Public Service Act, the Defense Act. They all employ this labor and employment. That's where this comes in. Review, despite any other act, any decision of anybody or official provided for in terms of any other act. That's the Public Service Act. If the decision concerns a matter within the scope of this act. But it must be within the scope of this act. Where do you get the scope of the act from? How do you determine the scope of the act? You should write it down. Don't tell me, write it down, I'll ask. And you show it to your friend. Write it down and show it to your colleague. That's, the act is full of qualifications. You must be very careful about each qualification if the decision concerns a matter within the scope of the act. So don't say the Public Service Act, Prisons Act. What you are reviewing must be on a matter which is on labor, is on employment, but it must be within the scope of this act. Where do you get the scope of the act from? Yeah, from labor, where? From page 1 to page, where do you get it from? Please don't tell me preamble. Preamble is only in the Constitution. And then the first Labor Act. And I know why it was there. The minister responsible wanted the act to have a nice aura. And you saw preamble in the Constitution, so we want preamble also in the Labor Act. But where do you get the scope of the act from? It's from the long title. Long title. Not short title. Short title is the Labor Act. Long title. That's where you get the scope of any act. The long title. So if what you want, the court is reviewing, even though it's about labor, it's about employment, it's in the Public Service Act, Prisons, the Correctional Services Act, Defense Act, but is it within the scope of the act? And it is because of this section, this article, that people are able to bring matters from the public service on review. Okay. The last thing I will touch so its review is 1B. If you read the act, you'll find it. Because it's the Labor Act, as I say, it's not a review in terms of the common law. It's not a review in terms of Article 18. Why does Article 18 not come in? Let's say you're reviewing. That is section, those who have got the act, 85, 4 and 5. That's what the review is. 85, 4 and 5. Sorry, 89. 89, 4 and 5. The labor is a party to a dispute who alleges a defect in arbitration proceedings in the terms of that may apply to Labor Commissioner for an order reviewing and setting aside the order. So that's why, so it's not reviewable in terms of the common law. It's not reviewable in terms of Article 18. the Act proposes its own review mechanism. And this is about arbitration proceedings only, not any other. Any other, it can be Article 18, it can be the common law. Remember, I said you can review decision of the minister. You don't do it under Article 80, Section 85(4)(5). Why? Because there are two review schemes. One is reviewing the decision, minister, permanent secretary, labor commissioner, any other body. Upon what grounds can you review their decisions? Upon what grounds can you review the decision of the minister, permanent secretary, labor commissioner, any other body or official? Or the one we talked about, you review decision so long as it's the scope of the Act. But when you go to 89, there's a review mechanism. When it comes to any other, it can only be common law grounds or Article 18 grounds. So Article 18 grounds, common law, do not apply when you are reviewing decision and arbitration tribunal proceedings. You see. The labor court may, a party to a dispute who alleges a defect in any arbitration proceedings in terms of this part may apply to labor court for the order reviewing and setting aside the award. Do so within, and it has defined what defect is. Don't be too smart as a judge and add some things to it. One judge tried to be adventurous. The Supreme Court told he cannot be. It's only this. It must be a defect. If you want to review proceedings of an arbitration, it must be a defect. And the defect has been defined. That the arbitrator committed misconduct in relation to the duties of an arbitrator. That is one. Two, committed gross irregularity, not just irregularity, but gross, serious one, in the conduct of the arbitration proceedings, or exceeded the arbitrator's powers, that is, acted ultra vires. Two, that the award has been improperly obtained. These are the only four grounds. So don't bring reasonableness, fairness, and all those that you see in article. We are all very familiar with. The last two exceeded the power, that's ultra vires. And then the other one is that the award has been improperly obtained. That's obtained by whoever was at arbitration. That's the most, don't go, and as I said, there are notes, and I've put the two latest cases which was discussed. So don't confuse 117B review with 11C review. They are different. You see, especially one arbitration tribunal's award. So B1 is just, that's 85. And the decision of the minister, those are, you can, because the minister is an administrative official. It's not a tribunal. The reason why you cannot use Article 18 grounds is that Article 18 is only for administrative officials and bodies. Arbitration is a tribunal in terms of Article 12(1), as 85 says. That's the only reason. And that's why the Act has supplied its own scheme of review. And the misconduct, committed misconduct. Misconduct should always be, there should be always malice or dishonesty. If the arbitrator was insulting somebody, that's not malice. That's not dishonesty. There must be an element of dishonesty, element of malice. And then gross irregularity. The most important is where the arbitrator did not allow. You who are magistrates know. where somebody is beginning to say, I know you, what you are going to say. You're not going to say anything sensible. Sit down. Or he asks a question. So no, that's a very bad question. That's been regular. Where the arbitrator descends into the arena on behalf of one of the parties, doesn't allow people to speak, stop them to speak. Actually, he cross-examines on behalf of one party.
If you repeatedly ask the question and the magistrate says, you already asked that question, is that...
No, that's why it's gross. That's why gross becomes important. It should be gross. Gross means something which can prejudice. He has asked the question, and because the person is not probably a legal practitioner, it's in cross-examination, he doesn't know that the answer is final. So he keeps on, he still wants an answer. Because he's not a practitioner, even some practitioners don't know that answer in cross-examination is final. Then you keep on, of course you can stop the person. Because the law allows you because he's acting illegally. And then a sitting arbitrators, when you are referring a matter to an arbitrator, we call it a reference. So the reference tells him what he must do. Let's say the person is asking for reinstatement and compensation. The arbitrator grants damages. We go back to that debate we had. Damages are English words. They mean differently. You can also damages, they say you pay money. No. They're English, they are not law words, they are English words. So if the arbitrator grants damages, he has actual travaris. The award has been obtained improperly. In fact, you won't see the word damages in the whole act. From page 1 to the end, you won't see the word damages. Because it's a technical term. Is he asking for special damages, which he must prove? Are they general damages? Arbitrator will not understand those. And that's why the act decided not to use the word damages at all. It's in the previous act. You created so many problems. The next one we'll do is better we do it next time. Urgent relief. So the last one we'll do is just urgent relief. Should I give you the note so that you read?
Yes.
I didn't think you would say no, actually. The most important before you read it is that an employee cannot, in terms of section 117, urgent relief is on 117E, grant urgent relief including an urgent interdict pending resolution of a dispute in terms of chapter 8. There must be a dispute reported labor commissioner before anybody can approach the court for urgent relief. You see some permanent secretaries, their contract is not renewed, they rush to the court. There's no dispute reported. There's a dispute between him and the government, of course, but it has been reported to the labor commissioner. It's not the high court. For labor court, it must be, that's the only power labor court has, 1171E. Grant urgent relief, including an urgent interdict pending resolution of a dispute in terms of labor. So you cannot say, I've heard I'm going to be dismissed. Then you write labor for us to stop the employer. you may have facts, yes, but is there a dispute? There must be a dispute reported labor commissioner. If there's no dispute pending, it must be a part B or part C. When I say part B, part C, I mean chapter 8. That's what the disputes are. Okay, so just read the notes and then make. No, there may be a dispute. But is it a dispute in terms of Chapter 8? Not that there's no dispute. There may be a dispute. Let's say you are a clerk, and the PS wife comes there, and you are looking at the wife, or he's angry. And he's angry with you, and you fight. There's a dispute. Then you write labor court for us to do what? There must be a dispute, reported labor commissioner. But that's not even a dispute also. You go labor to report a dispute of right. And before you do that, there must have been disciplinary hearing and all that. You may have facts and all that. The reason is that what does he do? There's nothing before him. Because he must take this dispute, appoint an arbitrator to arbitrate. If he fails, conciliate, fails arbitration. And one thing you should not forget, in our law, dismissal is still part of our law, whether you're a court or not. Dismissal is still part of our law. So don't somebody rush that I'm going to be dismissed. It's part of our law. There's nothing illegal about it. No, there are so many kinds of disputes. Let's say, in terms of your contract says every month you must be given an allowance for petrol. They can't give you a car. They see you have your own car. And you don't get the petrol. It's a dispute of right. You report Labor Commissioner that I have a right to be given an amount of gallons of liters of petrol. It was not given to me. It's not only dismissal, which is an industrial dispute, not only dismissal. Anything which is you have a right to. You have a right not to be dismissed unfairly. That's why it's a dispute, you report. So if your conditions of service says you must be given this every month, they don't give you. Then you report. Then it becomes a dispute of right. Okay, thank you very much.